Professor Stephen Macedo of Princeton University Department of Politics.
Provide a little visual variety by moving. Thanks to Jim for another terrific conference, and thanks to Ronald Dworkin for another terrific book. Unlike others who have spoken, I'm going to speak in agreement with one claim that Dworkin advances, which seems to me important, also familiar, and that having to do with judicial review and its relation to democracy. I want to argue here that we should stop talking about majoritarianism as a plausible characterization of a political system we'd recommend. I think it's a distraction. It clouds clear thinking about institutional assessment and reform on the basis of democratic principles properly understood. Now, Dworkin in this manuscript and in elsewhere, this is definitely old wine in new bottles, but as Jim said, it's quite good, I think. Dworkin seems to me correct with respect to a fundamental point which is very often missed. The basic principle of democracy is political equality, and there's an important gap, an interpretive gap, between that fundamental principle and other principles that are fundamental, like fairness, and the more concrete rules and norms that structure decision-making in particular institutional settings. Importantly, majority rule is not a fundamental principle of either democracy or fairness. It's not required by any basic principle of democracy or fairness. It's one among a variety of decision rules that may advance the project of collective self-government on the basis of political equality, but it need not. Majority rule is a decision rule that has some nice properties. It's decisive when there are only two options, but its virtues, both practical and moral, are easily and frequently exaggerated, and that's unfortunate. Now, an excellent discussion of this general terrain can be found in the book of my colleague Charles Beitz, Political Equality. And indeed, I think the core claim of that book, a core insight of that book, is to insist on this gap between basic principles of political morality, the principle of political equality, and more concrete questions of institutional design, including choice of voting rules, forms of representation, and so on. The questions of institutional design are rarely settled definitively by reference to fundamental political principles alone. So what I want to suggest in this very brief sketch in the paper is that the very abstract debate over democracy, majority rule, and judicial review has been conducted at too high a level of abstraction. The interesting issue is what constitutes the best overall system of collective self-government on the basis of political equality, with due deliberation and fair inclusion of interests and preferences. Maybe judicial review, strong or weak, designed one way or another, does or does not contribute to the improvement of collective legitimate self-rule, but we get nowhere in that discussion by worrying about whether judicial review is counter-majoritarian. We just shouldn't care. As Democrats, we shouldn't care. Judicial review is neither ruled out by first principles of democracy, democratic political morality, nor is it required by the first principles of political morality. Those principles need to be worked out, interpreted in particular practical settings and in the context of considering the difficult issue of optimal institutional design. And I think Dworkin has all this pretty much right at the level of basic principle and his pragmatic attitude towards institutions. So I think, in fact, there's a reasonable level of actual practical agreement between critics of judicial review and its defenders when we move down a level of abstraction. Now, okay, but why majoritarianism? Now, Jeremy Waldron, I knew he was going to be on this panel, and he got a copy of the paper, not too far in advance, but a little bit in advance. He's advanced a principled argument for majority rule based on political equality, and has argued that final decisions about political questions, including individual rights and political processes, should be made by majoritarian procedures. Majoritarianism can be supported on a variety of grounds, but one sort of simple and apparently morally principled ground is that when equal persons disagree about the rules and policies of a political regime, the fairest way of settling that disagreement is to give everyone an equal vote, and the side that gets the most votes wins. Majoritarianism respects our political and moral equality, it appears, by submitting political questions to a procedure in which everyone has an equal say. No one is regarded as more competent or worthy of having a greater say than anyone else. And so it instantiates one straightforward interpretation of the principle of political equality. Equal votes for equal people, and the greatest number wins. Now, Dworkin calls this deflatingly, and I think appropriately, the head counting principle, and argues that it has no necessary claim to legitimacy. It certainly lacks legitimacy if majorities oppress minorities and flaunt their rights. Waldron concedes this. Even at his most majoritarian, Some rights are conditions of democratic legitimacy. So the question remains, why should a part of the people, even the larger part, decide for the whole? Why should majorities make decisions even about, and I quote Waldron, the nature and limits of majority decision-making? Waldron has suggested an answer. Politics is characterized by pervasive disagreement. So we disagree over every standard that might be invoked to qualify or limit majority decision-making, including the content and scope of those rights whose observance is essential to democratic legitimacy. As Waldron has said, and I quote, "It is disagreement all the way down so far as constitutional choice is concerned. Since a part will always decide for the whole, it's preferable that the ruling part should be the larger part." Waldron doesn't rule out reliance on complex decision-making procedures, and he favors space for deliberation, but the majority should, it appears, be the ultimate decider when there's disagreement, and presumably complex procedures should not be too deeply entrenched in a way that's hard for the majority to change. Of course, it seems paradoxical to allow the majority to decide on the limits of majority rule itself, but as Jeremy says, majority rule at least allows a voice and a vote in the final decision to every citizen of the society, and when numbers rule, equality is in one respect at least preserved. So the argument, if I understand it correctly, and Jeremy's written a lot on democracy that is absolutely terrific, and this refers to one well-known essay, and I'll say something about some of his other work in a minute. But the argument seems to boil down, at the most abstract principled level, to the contention that we should prefer majority rule to minority rule in conditions in which we disagree about everything else. And there's nothing much more to be said than you have a greater and a larger number, prefer the larger number. To appeal to the contention that some non-majoritarian procedure would be preferable simply raises the question, preferable to who? A majority or a minority? Now, Dworkin, of course, argues that we have many grounds for valuing democratic procedures and participatory mechanisms, but when those procedures issue in legislation that seriously infringes on equal rights, equal concern and respect, the very values that democracy itself is based upon, then there's no overall loss to democracy when courts, empowered by a popular constitution, exercise the power of review to strike down legislation. And about that, Waldron says several things, many things, but I'm not going to only talk about several. There may be a gain to democracy in one respect, when a right essential to legitimacy has been unfairly denied by legislatures and courts protect it, but there's also a loss to democracy, Jeremy says, when unelected and unaccountable judges have invalidated a duly enacted law. But federal judges are not unaccountable. They're accountable in a certain way for the quality of their reasons. Elections are one form of accountability with a democratic system, but only one form, an important form, but a flawed form. Second, judges' decisions aren't final. Even in the United States, Supreme Court opinions that are unpopular will be overturned eventually. It is hard to overturn Supreme Court decisions in the United States, and neither Dworkin nor I would argue that the design of judicial review in the United States is optimal. That's not part of the argument. But we need to address these issues at a more retail level, issues of optimal design. Sometimes it seems that Jeremy wants to focus on the range of cases where differing legislative factions disagree reasonably. Again, we'd want to consider what's the content of this reasonable disagreement, exactly where should courts defer to legislatures who have exercised a reasonable but perhaps erroneous judgment. There might be an argument for some margin of discretion for legislatures out of respect for principles of democratic procedures that Corey, Brett Schneiders, and others have talked about. That could be factored in to justifiable exercise of judicial review. But when judicial review is exercised, taking into account those sorts of considerations, it seems to me Dworkin's correct to argue that there's no loss to democracy. So I think Jeremy's defense of majority rule is the best available, creative, original, and powerful. And I've engaged it here and will engage it elsewhere. But it seems to me unconvincing and ultimately, in his own work, even half-hearted. He himself clearly favors complex constitutional arrangements in his work on the dignity of legislation and elsewhere, designed to protect minority rights, promote equitable representation, and so on. His model of well-working legislative politics in the core case against judicial review includes many of the same admirable features as Dworkin's partnership democracy. He questions the legitimacy of unicameral legislative systems because he's afraid they don't adequately represent minority interests. And bicameral legislative institutions, of course, are supermajoritarian, not majoritarian. His most recent criticisms of judicial review, the core case, doesn't depend on majoritarian premises, so far as I can tell. So part of the problem here, and this will be the final point, is it's puzzling what people even mean when they describe a political system as majoritarian. Actual democratic polities employ majority rule voting in particular phases of a complex overall system. It has strengths and weaknesses. It's decisive when there are two options. When there are more than two options, there can be cycling and so on. But the representative and electoral systems of constitutional democracies often are typically empowered governments that represent only pluralities of the public. The government of Tony Blair, I think, was reelected with about 38% of the public vote, the three-party contest. Mass popular elections matter. They're dramatic and important moments in democratic politics. And legislative deliberation, as Jeremy argues, is often highly admirable, well-informed, conscientious, and dignified. But there's no insult or affront to legislative politics if, in designing and adopting a popular constitution, that constitution contains additional mechanisms that are also selected to further improve the quality of collective deliberation, including courts with the power of review. So I think we should just dispense with the word majoritarian as a description of legitimate and attractive political processes, and instead consider when majority rule voting makes sense and when it doesn't. Majority rule voting is one of many possible decision procedures that are consistent with political equality. Other decision rules are also consistent and may be fairer and more inclusive. Multi-winner rules can help ensure minorities get their fair share. Preferential voting, sometimes consensus, is a reasonable aim. Supermajorities might, and in the real world often do, prefer systems of collective self-rule in which minority interests gain special protection. We all might prefer that, given the possibility of finding ourselves in a minority. So majoritarianism, to conclude, is not a uniquely authoritative or legitimate decision rule in conditions of disagreement among political equals, at least in the real world as we know it. In mathematical models, of course, that abstract away from reality, as I said, majority rule does have some decisive and interesting properties. Majoritarianism as an ideology is a simplistic and morally unattractive solution to the problem of collective self-rule amidst the great diversity and disagreement of modern mass societies. It's not a promising way of taking seriously the principle of fair treatment that we should also want our politics to represent. The equal distribution of votes does not secure the equal standing and status of citizens. Judicial review should also not be fetishized, and I don't think Dworkin fetishizes it. He says, in fact, nothing guarantees in advance that judicial review will or will not make a majoritarian community more legitimate and democratic. We have to assess the court's contributions at retail. So the challenge, I think, when it comes to institutional design, which is a very difficult question, is to be fair in our assessment of particular institutions while realistically assaying the opportunity costs of engaging and mobilizing for constitutional reform when political energies are scarce, and doing that on the basis of a defensible account of the values of democracy. I read Dworkin as adopting a sensibly pragmatic attitude towards institutional design, and only insisting that we should take an interpretive posture towards the institutions that we have, making them the best they can be, while also considering how they might be reformed. Thank you.